Usually I have a stack in the car, but I use them up and then replenish them. That's my email, my office number, my cell number. Happy to talk to you guys about whatever's going on, transaction-wise or otherwise, real property related. I've been an attorney for 20 plus years. A lot of it's transactional work, just advising brokers and agents about getting their transactions through so you guys can get paid. This seems the biggest issue is getting transactions done sometimes. Sometimes there's legal issues, that come up. Are we on? We're good? Good? Okay, great. Okay, so I want to talk about a few things. I won't take too long talking, maybe half an hour, and then we can open it up. Actually, what I'll do is, after each section, I'll open it up to questions about that section, and then at the end, we'll open it up to general questions or other things. So first thing I'll talk about is some new laws that came in 2023. These are, there's always new laws that come in California. January is usually a new batch of laws come in. Some of them have to do with real estate. There's a lot that have to do with real estate this year, but only a few of them I think are really important for you guys to know. The first one I want to touch on is broker. If you're applying for your broker's license, you need to have, the law has changed to you need to have 2 years of experience within the last 5 years before you apply. So it used to be you just need 2 years of experience, and then you can apply for your broker's license, no matter when you got them. But the new law says you have to have the 2 years within the last 5 years before you apply. So you can't wait too long. You can't have real estate experience in 2002 and then another year to this year and then apply. It won't work anymore. You have to have 2 within the last 5 years. Okay. For a number of years, California has been fighting HOAs. And the reason why that is because HOAs are more restrictive than California law on a lot of different things. And California doesn't like that. So, a few years ago it was solar panels. HOAs used to say to their members, you can't put solar panels up. California said you got to cut that stuff out. So there was a law that came in that says solar panels are allowed, even on HOA properties. ADUs were a hot topic. Like the HOAs were saying you can't build ADUs on the premises. California said knock that off. ADUs are allowed. Personal marijuana growing. That was a hot topic too. Associations were banning that. California says, nope, state law. We're allowing people to grow their own marijuana for medicinal purposes. So this year, they've made a new law with regard to renting. So generally, HOAs can limit the amount of rentals to 25% in their communities. So if you buy into an HOA, they can have a CC&R that says, if you have an investor client, it could be a CCR in there that says, only 25% of the units can be rented out. So they can have that cap on there. What the new law is this year is that HOAs can no longer prevent owners from renting out space in their property if they live there.
I was just going to ask you that because where I live, there's what we call multi-family. They actually split the house and it's another section of another auditorium with the whole sink, the whole thing. And one of our neighbors was saying that the HOA was saying that they can't do that.
So you got to think about a couple of things there. If it's done legally through the permits and stuff, then the HOAs can't stop it from happening. But if it's done illegally, they didn't get any permits, they just put walls up, then you have another issue.
Now, this is built like that.
It's built like that?
Yeah, the building's built like that.
Yeah, so if it's a single unit and just divvy it up in a certain way, and then and you're renting space in your unit, they can't prevent you from doing that.
It's called the Gen Suite.
What is it?
The next Gen Suite?
Yeah.
They can't prevent that, I don't think.
Yeah, I didn't think so either.
Why built that way?
Right. So, but HOAs, the problem with them really is that I don't know if any of you are on HOA board, so I apologize. But they're kind of like they're like ruling their own little country or something. They make all these weird rules, and I'm not a fan of them. So,
not at all.
So that's a new law that came in. I want to talk about partitions for a second. So partitions are a type of legal mechanism that allows people who are on title together to get off of title. So essentially, If you're married, obviously, then it goes to divorce court. If you guys want to liquidate your assets, it goes to divorce court if there's marriage. But a lot of times what happens is there's no marriage. It's like boyfriend and girlfriend, or brothers or sisters or whatever. And they're on title together, and they don't want to be on title together anymore. They've had a fight, fights about what to do with the property. That legal mechanism to dissolve that is called partition. If there's no agreement by the parties to sell, it's called partition, because one party wants to sell, the other party doesn't want to sell. For years and years and years, that mechanism meant they had to sell it to a third party. They had to sell it out to a third party buyer. The law changed this year, and this year the court has the authority to essentially order the buyout or the sale to each other. So if people are entitled together, the court can order it sold to the other party. Now, and the court has the authority to order a broker or a real estate agent to be appointed to do that, okay, and to sell the property. So if you guys are faced with a situation where you have a listing with somebody who says, I'm not the only person on title, but I want to sell, the other person doesn't want to sell, which happens a lot, take the listing anyway. Eventually that house is going to get sold, either through law or through us getting involved in an attorney writing a letter. Most of the times those houses get sold. They have to get sold because the law generally is they're not going to hold people on title together that don't want to be on title together. The house is going to get sold. So to get a long-term listing, and at least if you have the listing in your pocket, we can tell the court that we have the agent. They already have a listing agreement with one of the owners, so we might as well appoint them to sell the entire property or to sell it to each other. Okay. So that's something that you guys should consider taking listings. Don't shy away from it just because the other owner doesn't sign. Again, your listing agreement with one owner is valid. The problem is that title is not going to allow you to sell a property unless you have all owners agree, right? So that's the issue. So we have a lot of those cases. Partition cases are we have a lot of those. The other cases we have a lot of is quiet title, where there's just messes on title. There's problems on title. Whether it's like a lien that's never died, a mechanics lien that's never been done something with, a deed of trust that's never been reconveyed from old days. There's an issue with title. There's an uninsured deed in title. Have you guys heard that term, uninsured deed? So title companies are insurance companies, and insurance companies by their nature are risk management entities, insurance companies. So from time to time, title companies get a little bit more, and it's weird because it all happens at the same time. Like all these different title companies, it's almost like they all got together in this big conference room and say, okay, now we're going to be very cautious about our title. So sometimes they'll just, for whatever reason, they'll say, well, we can't sell this property because 10 years ago there was a deed that was given from one person to the other without insurance, without title insurance. So title companies will get into those modes where they require you guys to get a court order to clear up title. The worst one I still have, this is like the worst one I have right now. It's just the most bizarre thing ever, right? So a guy died. He bought it. This guy that died bought it in 1958. Never took a mortgage. Never refinanced. Never tried to sell. From 1958. How many years ago was that? Holy moly!
58. That's 60.
70.
72.
70. Okay, so from 72 years ago, never refinanced. Never took a mortgage out. Never tried to sell. He passes away. He has a trust, which is good. The trust passes it to his brother, who's a trustee. The trust, right? Cool. The brother wants to sell the property, right? Because he's the trustee. Title says you can't sell it because there's a problem with title. The problem with title was from 1957. Okay, so what happened in 1957 is the initial people who owned the property, and by the way, if you look up title, the people who owned it from like the 40s are still on title. And the reason is because the people who owned it in the 40s gave a deed to the second owners in 57. The second owners never recorded that deed. They held on to it, they never recorded it. And then in 58, those people that never recorded their deed sold it to the dead guy who recorded his deed, obviously. So there's a break in title. There's a 1940s title, there's a 1958 title, but there's no 1957 title passing it on to the middle people. So title says you gotta file an action to quiet title from 1957. So that's the worst one. That's the craziest one I have, right? But that happens. Now, is it going to be a very complicated case? No, it's just a matter of filing papers and getting it through. But that's what title's telling you.
How much does that charge somebody?
How much should I charge somebody for that? Normally, if they're going to sell the property, I take it on the back end. And usually it's going to cost about $10,000. I have been burned before, though. Like, I've been burned where somebody says, "Yeah, I'm going to sell the property," and then they don't sell. So usually I kind of have to figure out what's the motivation behind the.
Did you put a lien on it?
I think they agreed to a voluntary lien. Yeah. So when they sell it eventually in the future. But yeah, I'm not in the business of putting liens on people's property. I want them to pay me up front if I can. So, all right, lead. So we have a lot of quiet title, a lot of partition. If you guys hear of anything like that, we can certainly handle that. Lead renovation, so lead paint. Okay, there's a new law that came into play this year that says you have to, if you do a lead rehab, you have to have a certified lead expert involved in that process. So you can't have the seller do it themselves. You can't have like a contractor, general contractor do it.
It's going to be disposed of a certain
unless you have a lead certificate. So remember that if you're ever asking for lead repairs under FHA or something like that, you have to have a lead certificate. Or if you're a listing agent and your seller is telling you, "Hey, I can just scrape off this paint myself," you have to have a certificate. Okay. All right. Changes to the RPA. That's probably why you guys are here, right? So this is the new RPA. This is the 2022, December 2022 version. The nice thing about CAR is that if you go into the CAR website and log in, don't go into zip forms, but go into the upper right-hand corner and search like December 2022 forms. It'll show you all the forms that have been changed or added. So one of them is the RPA. And the reason why you can tell it's been changed is because there's red lines in it. So the red is all the changes they made, which is easier than looking at it black and white and trying to figure out, comparing it to the other one, right? To the old one. So this is nice to have red lines in there. So all the changes that CAR made are in red on this form, which is really helpful for me. So I want to focus on a few of the changes that are most important to you guys. You guys have heard of section 3G3? No? Oh, I'll explain it. You guys will, I'm sure once I'm done, you guys will know what I'm talking about. So section 3G3. Okay, remember the 3 series is all these check boxes you guys have to do on the RPA, right? So 3G3 has added a box that said seller agrees to pay buyer's broker compensation. You guys know that?
Oh yeah.
Okay. So here's the bottom line with that. And I've kind of led through this a few times, and I've talked to people who are a lot smarter than I am. If you are willing to live by the MLS compensation, you don't need to check that box. So if the MLS is offering 2%, you said 2% is good enough for me, you don't need to check that box. There's no reason to check that box. Because when you check that box, you're asking the seller to pay your compensation, and then you have to produce a contract that you have with your buyer. Okay? And they made a new contract. We'll talk about that in a second. But if you check that box, you're asking the seller to pay your compensation, and you have to fill out a form called the SPBB, which is a new form, attaching your buyer-broker contract. Okay? But if you're willing to live by the MLS compensation or the CBC compensation, there is no need to check off that box at all. Right? Now, I will tell you this. CAR is going to be driving the point home over the next couple of years that you guys, as buyers brokers, buyers agents, need to have contracts with your buyers. They are pushing you guys to have contracts with your buyers. NAR was involved with a bunch of lawsuits on the East Coast, and CAR has been trying to get ahead of the game. They want to push you guys to get contracts with buyers for compensation because they want sellers to stop paying buyer broker compensation on the closing statements. Okay, so you need to, you're going to have to get used to the idea of entering into a contract with your buyer for compensation. So when do you use this box? You use this box if you have a contract with your buyer and the MLS offer is not good enough for you. So the MLS is offering $500. How many of you guys have seen it on the MLS?
Believe it or not.
Okay, yeah. MLS is offering $500. You talk to your buyer and say, there's no way I'm going to do this for $500. You might as well go straight there.
$1 million home, 2,000.
No, but I want your services. Great. Sign this sign this compensation, this buyer broker agreement, right, with me. So you have the buyer sign something with you. The buyer says you're going to pay 1%, 2%. Great. Then you check off this box with your offer, and you send it to the seller and say, I want you to pay the broker commission, the buyer side commission. The seller may say, no, I don't want to pay it, counter it out. The seller may say, not counter it out, and then they're required to pay it. But if they counter it out, you go back to your buyer and you say, seller's not going to pay for it, you're going to be responsible for it at the end of the day. That's the conversation. That's how it goes. That's when you check off that box. Because essentially what this box means is that what you're being offered is not good enough and you want to get paid more than what's being offered on the MLS. And you want the seller to pay it. The seller may say, I don't want to pay it. You got to go to your buyer and see if you can get paid through them. Okay. The nice thing about the buyer-broker agreement, though, is that once the buyer signs that, they're on the hook to pay you. Because the way that agreement is structured is that you can have them pay a commission, and you can set the parameters of payment of the commission. For example, if you find any house with or without me in San Bernardino, Riverside, San Diego County, of $0 to $500,000, then I get paid. That's how it's written. It's written almost like a listing agreement for buyers. Okay? So it's nice to have that contract with the buyers. It's not done as much in Southern California, the buyer-broker agreements, but they want you to start doing it. And they're driving toward you guys doing it.
Is there a time where they're gonna set that?
Well, I think it's coming. I think what's going to happen is that the idea of slowly, not like right away, but the idea of sellers offering commission to the buyer's agents is going to slowly go away.
Is that a result of the class action lawsuit?
Yeah. I'm trying to get ahead of the game. Yeah. So to that effect, CAR has put out a new form. It's called the BRBC form. BRBC. The buyer representation and broker compensation form. That essentially takes over for all the other buyer-broker agreements. It used to be a buyer-broker exclusive, buyer-broker open, all this stuff. This form consolidates all those forms into one form called the BRBC. And this is the form you're supposed to use to enter into a contract with your buyer. Okay, so get familiarized with that. If you don't use it now, you will be probably using it in the future. Get ahead of the game. Okay?
I'm sorry, is that on the card forms or
Card forms. Yeah, card forms.
Wait, what is that again? What you said? DRPC.
But that's for a form when you get into a contract with the buyer?
Yes.
You're talking about like if you sign a buyer broker agreement, you also need to sign the BRBC?
This is the buyer broker agreement. This is the new one.
Oh, okay.
Okay.
And that comes in effect as of when, sorry?
This year. Yeah, I mean in January. So, the one I have here says 12/22. So yeah. It's a new form. Okay. Section L, RBA section L, 3L2. So 3L2 has not been changed, but 3L2, the reason why I'm bringing up 3L2 is because this is the contingency, this is the appraisal contingency section. But the reason I'm bringing this up is because all counter offers have been changed. So the buyer counter offer, the seller counter offer, and the seller multiple counter offer have been all changed. And they all include now this language, which if you understand this off the top of your head, then you're better than me. But I'll explain what that means. So all the counter offers, BCO, SCO, SMCO, say this now. Unless otherwise agreed or altered in another counter offer. If in the original offer, the appraisal contingency amount is lower than the original offered price, then the dollar amount of any difference shall be deducted from the final contract price to create the final appraisal contingency amount. Everybody get that, right?
That means that the price of the
appraisal has a lower-
we're going to lower the price to that price of the appraisal.
Almost, but not exactly. Oh, you're almost
So
on.
you're not talking about paying the difference.
You're almost on the right, but it's not exactly right, because they're not going to force the seller to lower the price. But
We're just going to deduct it from the net.
well, here's what they're going to do, right? So if you look at L2, right? If you look at 3L2, 3L2, the contingency says appraisal contingency based upon appraised value at a minimum of purchase price, or there's a box and a dollar sign and a line, right?
Yeah.
What was happening when the market was hot was buyers were saying, this house is being offered for $500,000, but I know it's not going to appraise for $500,000. It's going to appraise for $490,000. So in order to signal to the seller that I'm willing to come out of pocket, I'm going to check off this box and put $490,000 on the appraisal contingency. So what does that tell the seller? Because the price is $500,000, that's what they want, and the buyer is checking off the box and saying $490,000. So what are you telling the seller as a buyer's agent?
Well, they'll pay $10,000.
You're going to come out of pocket $10,000, right? But then what was happening was the sellers were getting more than one offer, and the sellers were going back and saying, no, we want $510,000. So now if the buyer agrees to that, and the contingency is still $490,000, what is the buyer out of pocket?
$20,000.
$20,000. So in order to remedy that contractually, that's why the language in the for example, the SEO says what it says. Now, if the seller says, I want, $510,000, which is a $20,000 gap, the appraisal contingency stays at $10,000. So essentially, it has to appraise for $500,000. The buyer can't come out of pocket more than $10,000.
Even if it came in above?
Well,
I'm confused. Between
the $10,000 that the buyer's coming out of pocket is going to stay $10,000 no matter what the buyer offers.
Okay.
You see what I'm saying?
So is there a way around that? If the seller's saying that, no, I want more, so it's a $20,000 difference.
The only way you do that is you have them waive the appraisal contingency if you're on the listing side, right?
Mm-hmm.
But it's protecting the out of pocket for the appraisal contingency, the out of pocket for the buyer at the initial gap, at the beginning gap that's in the contract. That's what's happening.
So my understanding is right. So if there's an agreement, the $490,000, it comes in at say $510,000.
No problem, right?
My buyer's only going to be out $10,000.
If the appraisal comes in at $510,000, there's no problem, because if it appraises for the purchase price and the buyer has no issue.
But I'm saying if it were $490,000, if we wrote $490,000.
If it appraises for $490,000, so let's say assuming it appraises for $490,000. So let's restructure this example, right? Initial list price was $500,000.
Okay.
The buyer says it's never gonna appraise for $500,000, but it's gonna appraise for $490,000. So I'm gonna write down $490,000 as the appraisal value. That way the seller knows I'll come out of pocket $10,000 if it doesn't appraise, right? For $500,000.
To make it $500,000.
To make it $500,000. But the seller says, no, I'm not happy with $500,000 anymore because I got multiple offers. I want $510,000. All of a sudden, the gap between what the buyer thinks it's going to appraise for and the contract price is $20,000. But if the seller does not counter out the appraisal contingency, with the seller's counter for the increased price, the language is built in where the buyer's $10,000 gap is protected. So there's the new appraisal amount is protected at $10,000 of a gap. Buyer never has to come out with a pocket $20,000 unless they agree to it. See what I'm saying?
So if you agree to it, do we have to attach an addendum to that?
Yeah, if they agree to it.
You really don't want to also remove your appraisal contingency, because I don't suggest that at all.
Right.
But you can put a gap up to a certain dollar amount.
You can play with the numbers and you can
Okay.
draft a contract whichever way you see best. But what it is that people were forgetting to do that. And then all of a sudden, the buyer at the end of the day is looking at a $20,000 difference, and he's like, "I never knew I had to come out of pocket $20,000 because we don't know what the appraisal is going to come in."
Right. Okay.
So now, understand something about cars that what they do, and the reason why the contract went from like 6 pages when I first started to 16 pages now, is because every year you guys call, right? You guys call car attorneys. They're constantly, they get like 5 million calls a day across the state. So if they hear these questions over and over again, or these problems over and over and over again, they got to look at it as, okay, we need to do something because people are confused. A lot of people are confused. We need to address it in the contract. Or there's a problem, we need to address it in the contract. That's why the contract is so many pages now, because they try to keep addressing problems as they get them every single year. So think of it that way. The car's constantly trying to address these issues. One of them was the appraisal contingency. The other one they're trying to address is solar. Well, before that, let's talk about the L series of disclosures, which is L4 through L7. 3L4 through 7. So these are the transmission of documents from seller to buyer. Okay. And those contingencies say, the buyer has 17 days. This is the standard method. 17 days after acceptance. It used to say 5 days after receipt. That's what it used to say. Okay. Now it says 5 days after delivery. And the reason for that is because Carl was hearing a lot of complaints about agents saying the other agent says they never got the email. They never opened their email, so they're saying they have 5 more days to look at the documents, even though the emails were sent to the proper email address. So in order to cut that out and not be reliant on the other agent's receipt of it, now it says 5 days after delivery. What does that mean? That means if you send it to a proper email address, it doesn't bounce back to you, it's delivered, and they have 5 days from when you send it, not 5 days from when they think they got it. That's another issue that they were dealing with at CAR, so they fixed it. The other thing here they fixed is tenancy. So 3M3. So the definition of tenancy has gotten broader. The reason is because sellers and listing agents were playing games with who's a tenant, who's not. Because if you have a tenant in the property you're selling, what form do you have to attach to your disclosures?
Tenant occupying plan.
TOPA, right? You gotta do that. What was happening though is that sellers were saying to their agents, you know what? She's not really a tenant. She's like my girlfriend's mother. She'll leave whenever I tell her to leave. Don't worry about it. There's no need to disclose anything further. What was happening is it was holding up the deal because the girlfriend's mother was not moving out. And then the buyer's like, well, I thought I was going to get possession of this property. All of a sudden, it's an eviction case that extends escrow for 90 days. So now the definition of tenant has expanded to anybody living there who's an adult, who's not the seller. So if somebody's living there who's not the seller, who's an adult, that you have to provide the TOPA form and explain what people are doing there. Okay, that's another issue that they wanted to address. All right. Q18, 3Q18. Q18 talks about home warranty. And Carl was hearing a lot of issues with home warranty plans because because consumers would call CAR and say, I'm complaining about my agent because my home warranty plan is not paying for anything, even though I have a home warranty plan, they're not paying for anything. And CAR would say, well, but that's between you and the home warranty plan. And they would say, well, but my agent forced me to get that plan. Which is not true. You guys are probably just recommending, use this plan. But the buyers were not getting enough, choices, right? Choice in they're not getting their choice, considered in the transaction. So they changed the section to say home warranty plan chosen by buyer. Okay, so they want you to offer your buyer to make the choice. Okay, section 11M. That's not under the 3 series. It's section 11M in the contract. 11M. There's a new disclosure regarding solar. Solar is another big problem that Carl was having for years because transactions were closing with solar contracts still on them. Solar leases were still on the properties when transactions were still closing because nobody took care of it during the transaction. So now there's a specific section regarding solar. And if there's solar, there's a specific now form to use for disclosure. And it's form, this is really tough. I don't know if you guys can remember this form.
Oh my
Oh,
God.
man.
All right, so you got to fill out that form if there's solar on the property. That should print out with the contract, I think. Okay, section 12B2. 12B2 has been added. This is the investigation contingency for buyers. A section's been added to it that specifies that the buyer's ability to get insurance, home insurance, is a contingency. Because what was happening sometimes is sellers have had a lot of claims on their policy for floods or water or whatever. It's difficult for the buyer to get insurance. So this is now a contingency in the contract, 12B2.
That's a good one.
Last section I'm going to talk about with the RPA is section 25I. And Carr tried to clarify under 25I the dates of performance under notices, right? So, for example, notice to perform, demand to close escrow, right? Notice to perform is 48 hours, right? So let's assume that you serve a notice to perform the Friday before Memorial Day. So you got Saturday, you got Friday, you serve the notice to perform. You got Saturday, Sunday, Memorial Day, Monday. When is the first day that you can cancel if you serve it on Friday?
Tuesday.
Tuesday is correct. The reason why Tuesday is correct is because you don't count, well, first of all, you don't count Friday. Friday is day 0. I don't care when you send that form. If you send it on Friday, it's day 0. The first day is Saturday. Saturday, Sunday are counted even though they're weekends. The day to perform then becomes Monday, but Monday is a holiday, it goes to Tuesday. So you count the holiday days, you count the weekend days, but you can't perform or you can't cancel on those days. Now, if you're a buyer and if you want to perform on those days, you're certainly welcome to, right? So if you remove contingencies on Saturday or Sunday or Monday, that's fine. But the trick is that the selling listing agent cannot cancel the contract until Tuesday. You can't send cancellation on Monday, it's not valid. Okay, it's a holiday. Everybody on the same page? Okay. All right. So we talked about the buyer representation agreement, the BRBC, which is a new form. There's a new form. They've actually changed the cancellation of contract form a little bit. They've tweaked it. And they made it very clear on the cancellation of contract form. You guys know what that form is, right? It has a top section and a bottom section. You know, cancellation of escrow, cancellation and deposit issue, deposit, you know. So they made it very clear on that form that only one party needs to sign the top section to cancel. But both parties have to sign the bottom section to release deposit. So I still get a lot of these questions from agents saying, I represent the buyer, seller's canceling on us, but my buyer is not going to cancel. So the escrow is going forward, right? The answer is no. If either party signs a cancellation, the top part, escrow stops. Escrow is canceled. Now, whether the cancellation is legitimate or not, that's a legal question. But escrow is canceled if one of the parties signs the top part of it, okay? Then the deposit is dealt with later.
I have a question about on the cancellation. What, I guess my question would be, what is illegal, or when is it illegal for a seller to cancel a transaction? Is it ever, are there valid reasons and not valid reasons? Like what's...
Well, let me put it this way. The seller does not have built-in contingencies in the contract. The buyer does. Buyer has built-in, unless it's waived, appraisal, loan, inspection, right? Those are the big 3. Right. Sellers don't have built-in contingencies, so you have to write it into the contract. That's the valid reason. Most of the time what's written in is the replacement property for a seller, right? Replacement property contingency. But the default on the contract is once seller agrees to sell, they're on the train to sell. And most of the time their cancellations are not proper if there's no contingency for them to back out. Okay? Now, it depends, it depends on the market whether a buyer wants to pursue the property or not. Because the buyer's remedy for sellers saying I don't want to move forward with no reason is to force them to sell. You can force them to sell, but it depends on the market. Because some buyers, when the market is hot and it's going up, buyers will want to force the sellers to sell. When the market is softer and there's more inventory, buyers don't want to get into litigation. They'll just go across the street and buy something. So it's market specific. Okay, extension of time addendums. There's a lot of confusion about extension of time addendums. Extension of time addendum goes out, and then it's out in an email somewhere, and nobody pays attention to it, and nobody knows whether the time is extended, or if anybody signed it, or what happened to it, right? So people were like, is my escrow still closing on the 15th, or do we extend time, do we not extend time? It's a lot of confusion about that. So they've changed the extension of time addendum to specifically say it can be withdrawn. So you can send an extension of time addendum out and say, I don't want to have it out anymore. You can withdraw it. Or if the other side doesn't sign it within 3 days, it's automatically terminated. So it gives it a little more clarity what happened to the ETA. So you guys as agents, if you send an ETA out because your client needs more time, and the other side tells you verbally, oh yeah, I'll sign it, don't worry. My client will sign it, we'll sign it tomorrow, we'll sign it tomorrow. If by the third day they don't sign it, you can't rely on them anymore, because essentially that agreement is dead, that extension of time is dead. So you got to be careful, right, about that.
So what would you suggest? Is emailing the agent and getting it in writing that yes, my client will sign, or is that?
It's not going to work. The client has to sign. Somebody has to sign.
Somebody has to sign.
Yeah. Otherwise, it defaults to the regular, to the existing timeline, right?
Got it.
So you got to be careful. Okay, so that's my spiel regarding the contracts and changes and things like that. Any questions on topic or off topic that I can help you guys with? Yes.
Yeah, I got one. I closed on a HUD home.
Oh, not supposed to be that.
The next day, my client's talking to the neighbor. Neighbor says that the wife shot herself and committed suicide in the master bedroom. HUD never disclosed it. So in my head, it's like, well, how?
HUD was the seller?
Yeah, HUD. So he's thinking about taking legal action and trying to sue the listing agent that was appointed by HUD. But in my head, it's like, okay, well, how are we going to know that they knew and they didn't disclose?
But that's the trick, right? Any non-disclosure issue, you have to show knowledge. We face that a lot by the seller. You know, we face that a lot with flip properties, for example. You know, properties that were like only held for 2 months and flipped. The problem is that you have to show actual knowledge by the seller or the listing agent that something was withheld, that they knew something and didn't tell you. It's not easy. I just defended a case. So my client was a flipper, and he held the property for like 2 months, and he had redone the kitchen. He had redone the kitchen, and he had redone the flooring. Right. So what he had done is he had put linoleum. What is it? Vinyl planks on top of the existing tile. He never like replaced the tile, never did anything. And he never like took out any of the cabinets. All he did was just paint the cabinets. So turns out that the seller, there was a leak in the kitchen that my client didn't know anything about. It was actually leaking to the outside of the house. So you used the sink in the kitchen, it was leaking to the outside. The buyer realized this because she was washing paintbrushes in the kitchen sink, and she saw colored water outside. She's like, wait a second, this is the same color as my paintbrushes. So she realized something was wrong. She got a contractor, and the pipe behind the cabinets was broken. Okay? So they took out the entire kitchen. It was moldy as you cannot believe. Behind the cabinets were moldy as you cannot believe. Okay? And not only that, but water was underneath the tile.
Between the two.
But not coming up, just underneath the tile, right? There was actually roots growing under the tile. So they sued my client for lack of disclosure. My client's like, I didn't know anything about that. The problem for them is they couldn't prove that the flipper knew anything about a leak behind cabinets when there's nothing showing to the inside of the kitchen. And we defensed it. They got $0. Their damages were $70,000, and it was provable. The kitchen was a disaster, but they couldn't prove seller knowledge.
Wow.
That's a big hurdle.
Yeah.
We noticed too on the contract, they have like a big old red stamp, bank owned seller.
Are essentially am I too far off?
I want to center you in the camera.
All right.
I'm picky.
The damages are the dollar difference between the price paid for by the buyer, the price paid by the buyer, and the condition of the property if it was disclosed. The appraised value if it was disclosed. The problem with something like that where somebody died on the property is not a lot of appraisers would put a dollar figure on that because it's a subjective issue. Some people really hated that people died on the property, some people don't care. It's not like a situation where you can put a cost of repair on it. So that's another issue, is the damages could be a problem for your buyer.
Yeah, I had a client that they did not have a problem, like if somebody had died in the property, they didn't have a problem with it. But if it was a suicide, yes, there was an issue. So even within the death spectrum, he was okay with certain things, but not suicide.
Well, you have to get an appraiser to say, okay, because somebody died in here, I would have reduced $50,000 from this.
Yeah, you can't.
Appraisals don't agree to that.
Yeah.
They don't agree on stuff like that. I've talked to like the top appraisers in the field, like people who have testified in court, and they're like, we don't know what dollar figure to put on that.
Well, you can't put a dollar figure on that.
No.
And that's what's required legally.
Yeah.
So.
Emotionally, financially, there's nothing you can do in the house.
Then we talked about HOAs again. I sent you a text message about the HOA.
Tell me about it.
I'm sure you recorded it.
So she did a forbearance during COVID. So she had some back fees, set up a payment plan. She's been making payments.
That's the one that's what I read yesterday.
Yeah, now she's getting ready to sell, and they put a lien on the property for like $5,000. She's been making payments for like the last 4 or 5 months when she made the arrangement. She got a notice beginning of the year from a law firm hired by the HOA. Probably the law firm that the HOA is using because they lost all their insurance. So now she's like, hey, you have 10 days to respond, but we're going to charge you $11,000 instead of like the $4,000 that she.
But does she have an agreement for the $4,000?
She does have an agreement, and she has an agreement. I haven't seen it yet. I told her to send it so I can take a look at it.
That's the important thing. If she has an agreement saying that here's what we're going to charge you, they can't go back on it.
So, and the question is, because she's selling, she said, you know what, I'll just take money out of my 401k, just pay it. Does she pay the HOA? Does she pay the law firm that's now representing the HOA?
She needs to send something in writing to the law firm saying, I'm ready to pay. Where do I send the check?
Okay.
That's what she needs to do.
Now, does she pay their fees, or does she pay what the HOA fees?
Well, that's the issue, right? The issue is that what was the agreement up front about? You know, because she needs to have something. Now, sometimes they'll say, "Oh, you have something in writing," but it doesn't exactly say that.
Right.
Like sometimes they'll say, if in order for us to have this deal, you got to finish all payments by December 31st. If she didn't do that, then they can charge her more money.
Right.
So
The president of the HOA is like dodging her. Like she lives a couple houses down.
she just camped out in front of his house.
I have something too.
Sure.
So I got into a conversation with one of my neighbors, and she's bought her house last year. And 3 months in, she noticed mold growing on the outside of one of the bathrooms. So they redid the whole bathroom and found all dormant mold. But
dormant meaning not active.
Yeah, but the home inspection and the seller didn't disclose that it used to be a marijuana grow house. So I don't even know where to start with her on that.
Yeah, I mean, that could be an issue if they didn't disclose that, because that could cause some humidity, and who knows what they did in terms of rehab, right?
Mm-hmm.
Did they say they did any rehab in the property?
It was a cash offer. She walked into the open house, the listing agent represented her and took her away from her buyer's agent, and then cash, so no appraisal.
No appraisal, but she should have gotten the disclosures from them. About
I have her sending them to me. So.
And they do ask if there's been any rehab, remodeling, things like that on the disclosures. So.
But I guess the electrical was all
jacked up.
Yeah.
They had a home inspection?
Yeah, but it was the listing agent's home inspector.
Oh,
so.
But how is the house for her?
Well, she wants to sell it, yeah, but she bought it for $635, and she could probably sell it for $550 now.
Yeah, but me personally, if she's not gonna be your client, you're not gonna list. Why even open a can of worms, right? She wants to. You gonna see her disclosure? You said?
Yeah. Well, she's my daughter's friend's mom, so, and she's in my farm, so that's like my targeted audience right now. So.
Yeah.
Okay.
No, I mean, you try to be a resource.
Yeah.
That's normal. That's normal. Agents do that all the time.
Yeah.
I mean, it depends on what the disclosures say, it depends on what was what was represented during the transaction. Obviously, if they knew it was a marijuana grow house and didn't tell her that could be a problem for them.
For the listing agent, right?
Yeah, or the seller.
Both.
Or both.
I think. Well, she heard from the neighbors too. You know, because neighbors talk, and she heard from the neighbors that it was a grow house, and then she knows that the listing agent and the seller were friends. So I'm sure they were.
It's gonna be a new call form for neighbors, like.
Right?
No, I mean, honestly, neighbors are the #1 snitches in real estate deals. You know, I can't tell you how many times I have agents call me and say, I was just, in an open house, and the neighbor walks in and says, hey, this house is draining the wrong way, and there's water, whatever it is, some issue. And their question to me is, well, do I disclose that now that I know this information? So we have to figure out whether it's a disclosable thing or not. But yeah, that happens all the time. And if you think you're hiding stuff from your neighbor, they all know your business, right? So, if you say I've never had any plumbing problems in a disclosure, and your neighbor will, if there is any plumbing problems, your neighbor will know it. Because I've had plenty of cases where the neighbor says, yeah, we've seen plumbing trucks, coming down the street all the time. We're stopping at our neighbor's house. So, that's why I don't talk to my neighbors. I don't know what's going on.
Yeah.
But yeah, neighbors are the biggest.
So how, in the case that she does sell, and she does have to disclose that it was a marijuana grow house, even though she was not the one growing the marijuana, right? But she knows about it.
Here's the thing, though, right? If it's fixed, If it's fixed, it really should have no. I shouldn't say that, but in my opinion, it shouldn't have any, backdated stigma on the property. You know what I'm saying? Like, some buyers won't care. Most buyers won't care. It used to be a marijuana grow house, but now it's fixed. Again, this comes to the issue of what dollar figure do you put on a marijuana grow house? And I can't, no appraisal is going to give you like $50,000 for a marijuana grow house. I mean, if it's fixed, it's fixed.
But question too, John, usually when you're getting a loan and you're getting your insurance, it pops up if there was a claim on the house.
Yeah.
So things like that, and you go back to your seller or whatever, they come back and say, hey, this comes up. Like when I do my walkthrough and I see that they patched the ceiling, I'll take a picture of it, I put it on my Avid, seems to be some kind of patch. I don't say it's a water leak because I'm not an inspector.
Right.
Some kind of patch, and then I go and ask the seller, I see this, please disclose it because it's going to come out anyway. Right. So it protects me and it protects the seller. But in cases like that, if went through whatever that house is, if it went through the insurance, maybe they did an insurance claim, and it could have. There's proof.
That's another good point here. Is that your duty as a listing agent is independent of seller disclosure anyway. If you see something that the seller is not bringing up, your duty is to bring it up.
Mm-hmm. Question: if that scenario happens, and let's say you're representing the buyer, but you find out past the contingency period, is your buyer okay still to back out if something comes up on the insurance like that? That they
wouldn't that count as a new discovery, and it would give you 5 more days?
5 more days, yeah.
Okay.
Anything new you find out, even if after you remove contingencies, if it's material, you have 5 days to back out.
And that includes avids, right? If you get an avid after your contingencies are
the reason why it says that is because they don't want to have sellers kind of hold on to information until contingencies are removed, and then they tell, oh yeah, but we have a roof leak, So
Oh my God.
they don't want to trap. So that's why the contract says if there's any new additional information that comes out within 5 days, you can cancel and treat that 5 days seriously, right?
So would you recommend to do an ETA on a new discovery if we get an avid date, and then just do an ETA and send it out?
And if you don't get them to agree though, it's 5 days.
Mm-hmm.
So you got to be careful. So don't lull yourself to sleep saying, oh, I'm working with the other agent, and then you get past that 5 days, and then suddenly they say, well, you can't cancel anymore. If you do, we're going to keep your deposit. So I had one like that recently, where it was $25,000 deposit, and it kind of happened like that. Like the buyers found out they were going to build all around the property, because they had like this woodland area. Then they found out they're going to build all around the property, and the buyers are like, well, what the hell? Nobody ever told us that. So they told the seller, hey, they're going to build all around. How come you didn't tell us? we want $20,000 less now. We want to offer you $20,000 less. And the seller says, oh yeah, let me think about it. They waited for the 5 days to expire, and then they said, we're not going to reduce the price. But we were able to get their money back because we just, we wrote them a letter and threatened them. So we got the buyer's money back. But the 5 days was concerning. My conversation with the buyer was, they have a better case than you do. I can threaten them, but I'm just telling you, they have a better case than you do because you blew the 5 days, right? But we were able to be compelling enough in our letter to where they said, okay, we don't want any trouble. Here's your money back. Plus, they already have listed it, put it back on the market for money. So, any other questions? Yes.
I have sellers, and they just, a couple of months back, they received a letter from Caltrans saying that there's a segment of their 14 acres that runs through their garage and their driveway, and they're saying that that property belongs to Caltrans. Wow. And so...
through their garage?
Yes, through the garage. They came up, I was up there, they did the survey and everything, and they were so nonchalant. Oh gosh, we're just so sorry, but this is our property. But going forward, what they've done, they have redirected, the engineer redirected the 74 to not go through the house. But now the issue, Caltrans is saying, well, it's not our issue. We found out it's the railroad. What railroad? And what happened is the lady that owned the house in 1967, she donated that land to Caltrans because she couldn't pay the taxes. And so we're just trying to, we're trying to get this house sold, but how do you disclose that someone else has title to that? It's just a small piece of land. It's their driveway. And when we were there, I said, well, how can you do that? It's going to take out the garage, and there is a master suite above the garage. And he goes, oh, that was additional. I go, no, it wasn't. That is the original house. So they're being really nonchalant.
It's almost like an eminent domain situation.
Mm-hmm. Well, they aren't going to buy the property. They're not going to pay for that. So now they have a new, I was dealing with an agent who does the sales for Caltrans, but now she's no longer, she retired, so we have a new person, and now we're starting all over again, and I'm not getting any
This
answers.
is a closed deal?
No, we're going to list it.
Oh, you're going to list it.
And so it's, of course, I haven't taken the listing,
Right.
but I'm working with Caltrans, trying to,
Sounds like a disaster.
It is a disaster.
Paris or Elsinore?
It's Elsinore.
You want to try
It's
transportation first.
Well, Caltrans is transportation.
Yeah, but go to the transportation office down in Riverside. They can give you maps and all that stuff compared to being on.
Well, we have all that. It is a fact. It is a fact. It's been done, but how do you?
So it was built like on top of their stuff?
No, it was built.
And then
the lady that owned it, she donated it, back to Caltrans. So it originally wasn't Caltrans.
How'd she donate like part of her property?
Right, 1967.
Wow.
So that explains a lot. And the funny thing is they just got the letter.
You know what you need to do?
Nobody knows.
What you need to do is make a title plan.
I have a title,
So your seller got a title policy when they bought the house. Make a title claim right away.
Okay, the title claim does say Caltrans owns it.
Yeah, but I'm saying...
Is there a copy of a donation letter or anything like that?
But I'm saying, see if...
it's 1967, I don't know.
See if the title policy...
Should go back into the archives.
Sometimes the title policy covers that issue.
A title...
They can take the fight on for her.
Yeah.
Possible.
Okay. I know, it's crazy.
It is crazy. That sounds crazy.
Yeah.
But I've heard some doozies. Any other questions, guys? You guys all good to go, huh? I don't know if there's any questions on from the folks at home, but all right. Well, thank you so much for having me today.
Thank you.
You guys take care.